Good morning, students, and welcome to our 12th lecture on international law. And today we are going to talk about human rights and the protection of human rights. We also have to talk about both international human rights and the national human rights, or the protection of human rights both nationally and internationally. That is the topic of today: human rights. So, in order to understand what human rights is all about, we have to understand the relationship between the citizens and the state. Okay? Now, when we understand the relationship between the citizens and the state, then we begin to understand how human rights come to play an important role in the legal systems of the world, as the citizens' rights has to be protected by the state one way or the other. So we have to talk first about the relationship between the citizens and the state when we talk about human rights. One, a necessary part of constitutionality is the human rights, and the link between the population to particular sovereignty and particular territory, and also the democratic state is deriving its legitimacy from the people. There are two forms of relationship between the state and the citizens. One is a participation in public power and protection of individual rights. Now, having known these two relationships, we have to talk about the sources of these rights, like the natural rights, requirements for a certain quality of life of any living creature that is derived from that creature's natural rights. They are a result of essence of life, and the basic elements: the right to live, the right to exist, the right to survive. A basic value for any form of life is to preserve and protect the life. Okay? So these are the natural rights that we all have, that our states needs to guarantee us. Okay? The precondition for the formation of human rights are about two preconditions. One is the natural claim are seriously endangered, and two, their social conditions for their articulation. Okay? Human rights are based on basic patterns of human behaviors. Basic rights are patterns of human behaviors that are tested in time and experienced, and its existence is not related to the existence of the state. Okay? Now, there are five elements of human rights. We have versatility, fundamentality, abstractness, moral validity, and priority. These are the five elements of human rights. Now we know all these things. Now let us now distinguish between human rights versus state, the evolution. Have any of you heard of what they call the Magna Carta of 1215? The Magna Carta Libatum of 1215 is the foundation where the Human Rights Foundation was first laid. Then in 1628, there was what they call in the UK Petition of Rights. So after the Magna Carta Libatum, there is the Petition of Rights of 1628, and in 1679, it was followed by what we all know, what we have treated before, they call habeas corpus, that is mostly practiced in the common law systems. I'm sure all you students already know what habeas corpus means. We talked about it 100 times already in our previous lecture. Then this habeas corpus was established around 1679, and then in 1689 the Bill of Rights were enacted, and in 1701 Acts of Settlement was enacted. So these are the evolutions, at least the evolutions of the human rights in English system. Human rights is not clearly established in the continental European law or the civil law system. That is why here in Europe, we don't have what we call human rights lawyers here, because the human rights law is not common in the common civil law system. It is mostly practiced in the common law system. That is also why when I was talking about the detention of Simon Eber, I told you that there is no such thing as habeas corpus right in Europe or in Finland, where he is currently detained. If you see the evolution of human rights I just mentioned, you see that it is mostly focused on the common law system or the United Kingdom legal system. So that is where you talk about human rights whenever you talk about English system. Okay? Now, the revolutions and the articulations of human rights continued, apart from the what I explained, the English system. It has to be revolutionized somehow, and in 1776 there was a declaration of independence of the United States, followed by a Declaration of Rights of Man and of the Citizens of 1789, followed then by the Belgic Constitution of 1831. So it was actually the Belgium Constitution that introduced human rights into the continental European legal system, before it was followed by the Austria-Hungarian Declaration of 1867. So you could easily argue that the it was the Belgium Constitution and the Austria-Hungarian Empire of 1867 that actually introduced what we now have as human rights in Europe. Okay? Now, gradual penetration of human rights continued after all this development I just mentioned above. Then, gradually, human rights started penetrating in most of other regions, like rights not primarily articulated as protected by the Constitution, or some of them are mentioned in statutory prescription, such as civil codes, rights related to personal status or property rights, etc. Gradually, it started entering the constitutions or statutes of other nations. Okay, and this was, for example, the ABGB of 1811, and this is how it continued to penetrate into every system to what we are currently having generally after the Universal Declaration of Human Rights in the aftermath of World War II. Now, interpretation. Understanding of human rights is depending on the development of societies. Okay? Development needs for changes like rigid constitution by interpretation, flexible constitution by amendment or interpretation, then protection of human rights. Now that we have talked about how human rights evolution came, then the nation had to protect these basic human rights domestically. Okay? Domestically, human rights are protected via common courts, civil and criminal courts, as integral part of every proceeding. Yeah? Administrative courts by review of acts of public administrations. Constitutional courts by interpretation of human rights, review of jurisprudences of common and administrative courts, and then international, when we talk about European Court on Human Rights, Inter-American Courts on Human Rights, and in Africa, eventually we also have African Courts of Human Rights as the African section of the court that is protecting the human rights. Okay? Domestically, the domestic courts or domestic system of courts are of one, in ordinary proceedings or by special procedures to the Supreme or Constitutional Courts, or by other domestic bodies like the National Ombudsman, etc. These are the 3 or 4 places that human rights are protected domestically. So, ordinary courts in ordinary proceedings, special courts in special procedures, Supreme Court or Constitutional Court, and also by other domestic bodies like Ombudsman. Okay? How did the human rights end up in every nation's constitution? Now, human rights in constitutions are part of the constitution. For example, in German constitution or in the Netherlands constitution or in Belgium constitution, human rights is enshrined in their constitution directly. Secondly, separate documents of constitutional forces can also be a source where some nations enshrine human rights into their law. Like in the United States, you have amendments. In the Czech Republic, Slovakia, you have separate documents of constitutional forces there. We also have separate documents and customs. For example, in the UK, where we have the Habeas Corpus Act or the Human Rights Acts, they are separately documented in the United Kingdom. Also, individual actions were also possible as a way to establishing the human rights. For example, in Germany, everyone may complain against infringement of basic rights by public authority, broad review, all judicial remedies can be exhausted. In Switzerland, for example, there is public law action against cantonal laws, cantonal decisions, all cantonal remedies as well as federal remedies must be exhausted. Standing is granted to either personal interest or visual interest. Also in the Czech Republic, everyone may complain against infringement of basic rights by public authority or broad review, or all judicial remedies must be exhausted. Okay? Now, in Europe, most developed system of human rights protection, European Court of Human Rights, based on European Convention on Human Rights, under supervision of Council of Europe, or generally recognized by all European states as standard of human rights protection. Okay? Now we are talking about Europe. We have to talk about the first place where human rights was internationalized, was when they created the European Court on Human Rights. Now, the European Court on Human Rights was created because, as I mentioned before, that human rights were more common in the Anglo-American legal system, but then after the Second World War, when America uh, decided to create the New World Order, the Truman Doctrine introduced democracy and human rights into Europe. So they find the need to also establish this European Court on Human Rights. That is how it entered in Europe. And after exhausting all your local remedies in your country, that is when you can seek redress at the European Court on Human Rights. It has to be within 6 months since the last decision is delivered and will be changed to 4 months. There is a special form to be filled and set of requirements. The complaint is taken against the state for breach of convention by its acts. Judgment against the country, the obligation of the state to take measures in order to repay its failures. There are other European activities to protect human rights. One is the European Social Charter of 1961, the final act of the Conference on Security and Cooperation in Europe of 1975, also known as the Helsinki Final Act. After transformed in Organization on Security and Cooperation in Europe, bridge organization between Eastern and Western Bloc, active in peace monitoring mission in European conflicts before the European Union set in. The European Convention for the Protection of Torture and Inhuman and Degrading Treatment or Punishment, and the Council of Europe Framework Convention for the Protection of National Minorities. These are other sources where human rights was introduced into the European system. Okay? Now, in America, in 1948, there was this American Declaration of the Rights and Duties of Men. There was this Organization of American States. And between 1959 and 1960, American Commission on Human Rights was introduced. Also, in 1969, American Convention on Human Rights established Inter-American Court of Human Rights. Okay? Now, Inter-American Court of Human Rights is similar to the European Court of Human Rights. It was headquartered in San Jose, Costa Rica. There is about 7 judges for 6 years. These are the composition of this court. There is 21 states that accepted this jurisdiction. Peru wanted to withdraw during Fujimori regime. Trinidad and Tobago suspended ratification. US never ratified it. Strange, eh? America introduced human rights globally, but they refused to ratify the Inter-American Court of Human Rights. Who knows why? Well, that is a lecture for another day. Individuals are not allowed to make complaints in Inter-American Court of Human Rights. Only Inter-American Commission on Human Rights or member states are allowed to file complaints. Okay? Now, the proceedings. Individuals must first lodge a complaint with the Commission. Commission rules on the admissibility of the claim. If admissible and the state is deemed at fault, Commission serves list of recommendation to make amends for the violation. Only if the state fails to abide or if the Commission decides that the case is of particular importance or legal interest, will the case be referred to the court. The presentation of a case before the court is a measure of last resort. Okay? Now, we have talked about human rights evolution in Europe, human rights evolution in America. Now, there is human rights or quasi-human rights evolution in Africa. In late 70s, I think in 1979, there was a UN seminar on the establishment of Regional Commission on Human Rights with special reference to Africa. That was sometimes in 1979. Now, in 1981, the Organization of African Unity adopted OAU Charter on Human and People's Rights that came into force sometimes in 1986. African Commission on Human and People's Rights, created on the basis of this Charter on Human and People's Rights that was adopted by the then Organization of African Unity. Okay? Now, African Commissions on Human and People's Rights was finally established in 1987. Their function was 1. The promotion of human and people's rights, the protection of human and people's rights, interpretation of provisions of the Charter, and any other task assigned to it by the OAU Assembly. Non-judicial procedures outcome is decision and recommendation and or settlement negotiation. Okay? Then there is Asia side of the story. In Asia, there is no general organization in Asia. There is no court in Asia as well, because China is the boss there, and nothing goes without China's interest on it. And when it comes to human rights, China have their own definition of human rights. So in Asia, there is no such thing as organization that protects human rights, and there is no such thing as courts in Asia as well. Okay? However, there is ESIN, Intergovernmental Commission on Human Rights. It is only consultancy body of ASEAN, no direct procedure for individual, and it has no direct ruling function. Now there is a Middle East or Arab Charter of Human Rights that was accepted by Council of the Legal League of Arab States in 1994. It entered into force in January 2008 after 7 countries ratified the texts. The United Nations Office for the High Commission for Human Rights. The Charter contains provisions that do not meet international norm and standard, death penalties for children, treatment it endorses of women and non-citizens, equating of Zionists with racism, establishes committee of experts on human rights, reviews the fulfillment of the charter only. So you see, the Arab chapter of human rights was kind of strange, as I've already mentioned why it was strange, why it was not accepted by the United Nations, because they equated Zionism with racism. The death penalty for children was allowed, and treatment of women and non-citizens, bad treatment of women and non-citizens are allowed. So, based on this, it was not recognized by the international community. Now, there is the International Labour Organization. International Labour Organization, founded after the First World War, around 1919 or something. It is the oldest UN specialized organization, forum of employees, employers, and governments focused on social peace. It has its own procedures over non-observance of the treaty. Only labor unions are allowed to initiate proceedings. Then, after that, we have the big boss, the United Nations Organization. Okay? International Covenant on United Nations Organization introduced a lot of human rights charters. One is the International Covenant on Civil and Political Rights of 1966, establishes human rights committees of 18 members. It takes comments on cases and general comments. In 1966, optional protocols allows individual complaints to be submitted. International Convention or International Covenant on Economic, Social, and Cultural Rights of 1966 comprises Committee on Economic, Social, and Cultural Rights, and it only makes reports. Okay? ECOSOC, Human Rights Commission. UN Economic and Social Council of 1948 established the Human Rights Commission with 15 members, political rather than judicial body it is. Then the International Convention on Elimination of All Forms of Racial Discrimination of 1966, it has its own commission. But I forgot to mention that in 1948, there was this Universal Declaration of Human Rights that was also introduced by the United Nations. So these are the evolutions of human rights internationally, nationally, and this is how it is till today. And the United Nations is pursuing this human rights, greatly trying to better the world. Even the European Commission, one of the conditions for accepting all these Eastern European countries that are seeking to join European Union, the major criteria is complete reformation of their constitution, introducing a clear and strong foundation of democracy and protection of human rights. If you don't meet these very important criteria, you will not be considered to join the European Union. That goes to tell you how serious the United Nations and the European Union are trying to make the world better by introducing human rights in every condition or every constitution of every nation. This is where we come to the end of today's lecture on human rights protection and international human rights evolution. My name is Gabriel. My duty is to give you A or B in your law lectures in the university, for your bachelor's or for your master's programs. So guys, this is where we stop today for the international human rights protection nationally and domestically. I wish you guys good luck, and we meet again when we conclude this lecture on international law by talking about international criminal courts. Until then, enjoy your lecture, and we talk again next week. Bye.